On resumption after short adjournment. Thank you, Mr. Wolmerans.
Your Worship, I do not intend to regurgitate all the cases and authorities and the like that my learned friend for accused 1 and 5 have already dealt with. Just one or two points that I intend to deal with. I associate myself with...
Before we go there, let's place on record that applicant 2's heads of argument are accepted. I have got a hard copy thereof, and it's accepted into the record. It's marked Exhibit O.
Yes.
Thank you. You may proceed.
Thank you, Your Worship. Your Worship, as I've said, I associate myself with what my learned friend for accused 1 and 5 has said with regard to the various authorities that he has referred to. Your Worship referred to, in a question to my learned friend about the delays. What must be borne in mind is that applicant number 2 has been in custody since October last year.
Sorry, Councillor. Clarify yourself. Delays? What delays are we talking about?
Sorry.
What delays are we talking about? Let me
The
understand.
delays that Your Worship, well, it was first raised by my learned friend for accused number 1, and then you asked him about the delays. And I'm just saying, this bail application started in March.
Yes.
He's been in custody since October last year. And it's not as though he was unaware of this particular case. He was aware of it. And he was questioned about it at that time when he was arrested. So this is nothing new to him. And when he handed himself over through his attorney, then where does the flight risk come in?
Applicant 2.
Sorry, Your Worship.
Applicant 2 handed himself over.
Yes. Sorry, Your Worship. He was arrested in Johannesburg.
Yes.
My apologies.
Yes.
But he's been aware of this case all along. That's the point.
But he was in custody on another case.
Yes. But he would have handed himself over had he been given the opportunity to do so.
But Mr. Wolmerans, let's understand each other so that we will flow. Where does handing himself over come in when he was arrested in Maponya Mall and brought to KZN?
Your Worship, it doesn't come into it. What I'm saying is, if he was out on bail or out at the time that his co-accused, he would himself, because he's represented by the same attorney. Had he been out and not in custody, he would have handed himself
I
over.
think let's rather talk about what happened. Let's rather talk about what happened.
Yeah.
Did he hand himself over? Was he arrested?
He was arrested in Johannesburg.
So handing himself over does not feature.
It doesn't enter, as Your Worship points out. Now, as has repeatedly been pointed out by my learned friend, the state has not taken the court into its confidence, and Your Worship raised the question about the investigation and how far it was and so on. And if I may quote from the state's heads of argument, which unfortunately you have not had the opportunity to read, but if you go to paragraph 62.
Yes, thank you.
The state further indicated on Exhibit G that there are further investigations that are still outstanding in this matter. It has been indicated that there is all likelihood that further persons may be added as accused in this matter pending the finalization of investigations. it is not a secret that certain evidence is being followed up, which means that the investigation is not complete. There can be no other interpretation to that. Therefore, to indicate that certain people should have been arrested at present is jumping the gun. The state never mentioned that the door of investigation has been totally closed. The contrary is actually true. So the state are conceding that the investigation is nowhere near complete, which means there is going to be delays. All right? There's been a delay since February last year when the deceased was shot. The extradition proceedings, and if there is a person who can talk with authority, it is my learned friend for accused number 1 and 5, because when he was part of the DPP's office, that was his function, was to deal with extraditions. And, Your Worship, I have no doubt that he is not going to contradict me if I say an extradition from one country to another, as close as what we are, can take up to 2 years, if not longer. So we're not looking at a trial which is likely to take place any time this year. Your Worship, I'm not going to deal with the bank statements, even though I handed in accused number 4's affidavit. My learned friend for accused number 4, applicant number 4, will deal with the bank statements. But there's a lot to be said about that. Your Worship, it is not sufficient in a bail application to say that there is a risk unless that risk is backed up by evidence. In other words, the authorities have said that there must be a likelihood that a particular result is going to result because there is evidence to support that. Bail should not be refused merely because the police say there is a risk. Now, as far as accused number or applicant number 2 is concerned, there is no evidence to suggest that he is a flight risk. The mere, if I can use an example, if the state were able to produce an aeroplane ticket that was imminently to be used, then the state has reason to be concerned that he's going to be a flight risk. But merely to say he's a flight risk is not sufficient. Your Worship, the state has seen, and I can find nothing else in the state's heads of argument except which appears at paragraph 63 and 64, where the state deals specifically with applicant number 2. And page 60. It's on page 16, Your Worship.
Yes, I've got it.
Yeah.
Paragraph 63.
Now,
Dealing with the passport.
yes, dealing with the passport. Applicant 2 knowingly supplied false information in another bail application that he was not in possession of a passport. Now, if one goes to Exhibit L, at paragraph 3.5,
Yes.
he explains that. The position is, Your Worship, that when the accused was arrested, his passport was seized. It's not as though the police had to go and look for it. They were in possession of it. Up until today, they are still in possession of it. So to make a big song and dance about him allegedly lying when he says, look, it's a genuine mistake. The drafter of my affidavit made a mistake. I didn't pick it up. Can't hold that against him. And what is more, Your Worship?
How the drafter coming to confirm that I made a mistake, me, Miss or Mr. Drafter made a mistake.
Your Worship, it's not required. He doesn't have to prove every single thing he says. The state are aware of it. So what difference is it going to make if the drafter, who happens to be me, says, I made a mistake? Where's that going to take the court? It's not going to take the court anywhere.
But these are bold allegations made by the state that he lied. And the response by the applicant is that it is Mr. Volmarans who made a mistake, the drafter.
Yeah.
The state is aware, but is the court aware?
Well, that's what I'm saying, Your Worship. The court is now aware because he's put an affidavit up to say it was a mistake. It wasn't deliberately done. It was never deliberately done. But in any event, Your Worship, I submit that the state was wrong in putting up that affidavit, in fact, putting up those, that bail application. All right? And the reason why I say that, I've dealt with it extensively in my head, Your Worship, but as well, if you read section 60, where it deals with the record of bail proceedings, and I'm quoting now from the Act, the record of bail proceedings, excluding the information in paragraph A, which is for previous convictions and pending cases, shall form part of the record of the trial of the accused, following upon such bail proceedings. It does not say any proceedings. So those bail is not criminal proceedings. So the state were not entitled to use that because it is only admissible at trial, not any other time. And, Your Worship, as I say, I've dealt with it extensively in my heads. Now, paragraph 62, or rather 63 and 64 of the state's heads of argument are the only thing that they can point their fingers at the accused as having, let's say, done something wrong. He hasn't done anything wrong. It does not say subsequent proceedings. It just says trial proceedings. So they were wrong in using it.
But could it not have been misleading to someone who is not informed?
Sorry, Your Worship, I don't
Could it
know.
not be misleading to someone who is not informed, like the state, which is informed that the accused has the passport because it was seized upon arrest, to someone like me who does not have such information? Could that not be misleading?
Your Worship, not when it's explained.
So it is until it is explained.
Yes, it's been explained. In Exhibit G, they make this allegation. In Exhibit L, it's explained. The state have been aware of it all the time. They can't say we were not aware of the fact that the that the accused had a passport. They can't say that. They were aware of it. They were in possession of it. So, Your Worship, that statement was not designed to try and mislead the court. That's why there's an explanation. Drafter of my affidavit made a mistake. What more would the person listening to the affidavit expect? Your Worship, other than the submissions already made, unless Your Worship has particular questions, those are my submissions, that the accused or the applicant has discharged the onus. He has his personal circumstances, the fact that he's been in custody all this time, the fact that he is productively employed, that he contributes to the fiscus, that he has a family to maintain, I submit are all relevant, and when put into the melting pot for the court to decide whether or not those amount to exceptional circumstances, I submit they do. There are exceptional circumstances. He has more than one wife. He has a number of children that he has to maintain. So, Your Worship, by keeping him in custody, all we're doing is making his children suffer. And, Your Worship, one must bear in mind the business that he is involved in, namely the taxi business. That's cash business. You can't collect his income. And that income, those people who are employed by the applicant are not going to go to his wife and say, listen, your husband is in custody, so here the day is taken. It doesn't work like that. So his family are suffering as a result of him being in custody. And I submit that is a very serious consideration when it comes to bail. Unless Your Worship has...
Well, we have touched upon it, and I want to take you back to it. His business is in the taxi industry.
Yes.
By his own statement under oath, his family is involved in Malugazi faction. Yes. And some of his family members have been killed. Yes. Through the violence that is there, because that industry is volatile, particularly at Malugazi. Yes, sir. The risk that is there, if he goes out, that he may also be eliminated.
Your Worship, as you've said, he wasn't arrested at Malagasy. He was arrested in Johannesburg. So he's kind of divorced himself away from where the violence is. He's still running his business, but he's not living in Malagasy where the violence is taking place. He feels he is safe, because otherwise he wouldn't be bringing this bail application. He would probably say, well, I'd be safer in custody.
But objectively speaking, is he safe?
Objectively speaking, yes, because there's been other members of his family may have been eliminated. Other taxi bosses. This is something that happens every day, Your Worship. Not just here in KZN,
yes.
In all the provinces.
Yes.
But it doesn't mean that his life is under threat. His
not
life hasn't been threatened so far. As far as we know, we have no instructions to the contrary that his life has been threatened. So until there is a threat, an actual threat, not a speculation, then it's neither here nor there. Your Worship, I'm also advised that there has been government intervention as far as the taxi violence in KZN is concerned, which has resulted in a great decline of taxi violence in KZN. I can't give Your Worship percentages, but so obviously the state are doing something right.
You see, I'm raising this because it's contained in his own statement that the situation is volatile, and he cites particularly Maluga's rank, that there is that faction over who is to manage Maluga's rank. It's in his own statement. That's where I'm taking it.
I agree with Your Worship that that's what is contained in the statement, but he's not there. And he's not part of the faction that is trying to fight for who is responsible or who takes over the taxi rate. He has people working for him. And in any event, Your Worship, as was stated in his affidavit, I'm loath to use the word likelihood because the state uses the word interchangeably with likelihood and possibility. But any such likelihood, and one has just to refer to the Eastern Cape case, any likelihood can be overcome by the imposition of conditions. So if the court said, right, I'm releasing you on bail, but you may not go back to Malugazi. If he then goes back there, he's broken a bail condition, he can be arrested. All the state has to do is apply for a warrant for his arrest, and he gets arrested.
I think let's do justice to applicant number 2. Let's be fair to him. Let's give him a hearing. Allegations have been made by the state that applicant number 2 is part of the group. He received 133,000 rand from applicant number 4. Don't you want to address the court on that?
Well, Your Worship, yes, he did receive a sum of money for services rendered. That's what he says.
But that's exactly what I'm saying. Don't you want to address the court on that so that it is on record that we have touched on that as well? That's why I'm saying let's do justice to him.
Well, Your Worship, I believe we have touched on it. We've said the money we received is for services rendered. What more do we have to say, Your Worship?
No, it's not for me to answer. I was just bringing to your attention that
yes,
are you
Your
not
Worship,
omitting,
that's
are you not omitting that one aspect? Because
No,
it's allegations made against him.
I don't believe so, Your Worship.
Okay.
Because I believe that by saying I received money for services rendered, he denies that he was involved in any nefarious activities of murdering the deceased and his compatriot. He denies that. He says, I will plead not guilty.
You see, I'm raising this so that there are no aspects of evidence that are left not addressed.
Well,
That's why I'm raising this up.
Well, Your Worship, the services rendered are also explained by applicant 4. He says, yes, I received money. I distributed certain monies for services rendered. What more must he say? I'm sorry, Your Worship, I'm not questioning the court, but I'm saying.
But exactly, it's not for me to answer those questions.
No,
but it's for him to say there is this piece of evidence that has been tendered, and there is that piece of evidence that has been tendered, and that piece of evidence, my explanation is grant me bail because of my explanation.
Your Worship, and I believe that I've addressed that. Grant me bail because, yes, I received money, but it was for services rendered, not for any unlawful purpose. Unless there are any other issues, Your Worship, those are my submissions.
Well, I've drawn your attention to certain aspects. I cannot draw your attention to all the aspects. As I was saying, let's do justice to each and every one of the 5 applicants so that we give them a fair hearing, that whatever has been said on their behalf is answered and is addressed. If you are satisfied as his counsel that you have addressed everything, I'm not going to poke you and say that. Why did you
Your
do
Worship,
that?
I do believe that the relevant issues have been addressed in my heads of argument and also properly answered in the affidavits. So if there's some aspect of my heads of argument which Your Worship is unhappy about, I'm happy to address that.
It's not that I'm not happy about.
Well, Your Worship, I use the word loosely.
Mine is to address my conscience and make sure that at the end of the day I've been presented with all facts and all facts have been properly addressed. Not because I'm not happy about anything, but
Your Worship,
I want to do justice to everyone.
Your Worship, I use the word unhappy loosely. I'm not saying you are unhappy. I'm saying if Your Worship has concerns, I'm happy to answer those concerns.
Anything else, Council?
Those are my submissions, Your Worship.
Thank you.
Thank you.
Ms. Gilling?
Court, please, Your Worship, the heads of argument for the applicant has been filed with court, Your Worship, if that may be marked as an exhibit.
Exhibit P.
Exhibit P, as the court pleases, Your Worship. Your Worship, the Exhibit C is the founding affidavits of applicant 3. The replying affidavit to the state's opposition is Exhibit J. We stand by the content of those affidavits. We feel we've addressed what needed to have been addressed. The heads of argument have been filed. We feel that everything that needed to be addressed and highlighted in respect of the evidence had been addressed in the heads of argument. In respect of applicant 3, it is poignant to note that the evidence that was led is contained in numerous affidavits, Your Worship. The affidavits are incapable of being interrogated because nobody's being cross-examined. So in this respect, the submissions made in the affidavits are the submissions that stand before court. Court is now going to have to interrogate the truth or, I suppose, deception in these affidavits. Your Worship is left with a whole lot of truths. And there's none of the persons that had filed the affidavit that stand before court and say, I am lying through my teeth in respect of this. But anyway, so Tuesday I was here. Everybody is submitting whatever they've submitted in the affidavits as truth and as fact, Your Worship. So that is before court. That will be up to the court to decide, Your Worship. The heads of argument, in my view, that I filed on behalf of my client, addresses, in short, points that I had highlighted in my affidavit, Your Worship. There will be no further submissions. I have read the heads of argument of the states, and I have no further submissions in respect of the states' heads of arguments, Your Worship.
As a reminder, by the way, how many charges or how many charges is he facing other than this one?
How many matters?
How many matters, yes.
Your Worship, there are 4 matters. The one is in Chatsworth.
4 matters, just tabulate them.
I will do. The first
4.
one is in respect of firearm possession, and that is now in Chatsworth. It's actually an Umlazi matter, Umlazi Regional Court matter, but the court is sitting at Chatsworth Regional Court because of the facilities.
Possession of firearm.
Yes.
Two.
Then there is a second matter that my client is on bail for in DC 10. That will be for possession. I think there's a myriad of charges in respect of a shooting incident in which a person passed away. It's alleged to be a taxi-related incident, Your Worship.
Yeah, but what is the charge?
So it'll be murder, attempted murder, possession of firearm. I think in that one there might be an allegation. No, I think that's as far as that is. Then there is
This is two.
that
Three.
is two. The third one is the matter in DC 11. We're nearly finished with the bail application. We're ready to file ahead, Your Worship. That is in respect of murder, attempted murder, possession. Also MI2P in respect of holes in the vehicles that sustained the gunshots. Not money laundering or anything to that effect, an attempted murder, and also failing to assist a pedestrian that was injured. So it is also in relation to a shooting incident. It's a murder matter, and conspiracy, that is now in DC 11, Your Worship.
That is three. Four,
This is the one that we're dealing with here, Your Worship,
which is murder among
which
others.
is murder as well, yes, Your Worship.
Now, the question that comes to mind is propensity
Your Worship,
or alleged propensity.
yes, Your Worship, in this regard, we're sitting with an applicant that has no previous convictions, no pending cases. At his age, he walks in, the first matter he is arrested for, all link to all these matters. This is the Umlazi matter last year, April, Your Worship. At that time, and this is where my client's position comes into play at this point in time, having four matters against him. At the time, and it is so in my affidavit, the investigating officer says, clearly during the bail proceedings, it is the firearm that's linked to these 7 offences, and that is why he's opposing. And he lists the 7 incidents of murder. And the magistrate had said, so the applicant is linked to these 7 cases of murder, and Mr. Parbu then corrects her and said, no, Your Worship, the firearm.
Yeah, but the question is still standing.
Propensity.
To be linked with violent crime where there is a loss of life.
Yes, Your Worship, but that is where I'm saying that my client was then subsequently piecemeal arrested on all the other cases in that affidavit, where he was not linked to it. This is a roundup of usual suspects, Your Worship. There is nothing at this point in time that links my client to any of these matters. He's on bail on 2 of these matters.
Ms. Gilling, how can you say that? Are you in possession of the statements?
I'm not in
the content of the docket?
I'm not in possession of
So
it, Your
how
Worship.
can you say there is nothing that links your client if you are not in possession of the content of the docket?
We've dealt with the state's submissions on what they have against my client. And as much as the state can say they have a firearm that links my client, the state is, the defense is disputing that because we've addressed that firearm. And we said that firearm is not linked to this matter. And that firearm is not linked to my client. It was just that 7 persons were not in a home, not on a homestead, in a building at a tavern, arrested for those initial 2 firearms. One, I don't know where that gentleman has gone to. 5 were released, 2 were then charged. And then they're saying my client is now linked with the firearm, with all the offences that is alleged to belong to the firearm. It is not so that it could say that my client has a propensity to commit crimes, when all that is before court now is allegations that he's linked to a firearm that is linked to offences. That is all that's before court. It doesn't show that my client is a habitual criminal or there is a violent man, Your Worship.
I'm not in a position to say that he is a habitual criminal. But the question that comes to my mind is a person who is alleged to be involved in 4 matters
Sure.
that are violent related, where there has been a loss of life, is the conclusion, prima facie, that he has a propensity of committing violent offenses or to be linked with violent offenses escapable?
No, Your Worship, I would differ. I would say, had there been previous convictions, yes, then one would say you can conclude that the person might be a person that has a propensity to commit these crimes, but there's no convictions we're speaking of here. These matters, the evidence is not tested yet.
All these 4 matters are
Yes.
before courts,
And it all happened within 1 year. The arrests. Yes, Your Worship, that's
but they
correct.
are all before courts.
They are all before court, Your
And
Worship.
in all 4, he is an accused person.
That is correct, Your Worship.
And you say propensity does not apply.
It cannot possibly apply because he's not been convicted. To be arrested for an offence does not equate being suspected of being the person that committed it unless...
The word in this context, propensity, is used in what context? Is it propensity to be convicted of offences, or is it propensity to commit crimes?
The question would be, what points towards a propensity to commit offences?
To commit offences.
Yes.
Not to be convicted of offences.
Yes, but what points to the propensity to commit offences is the amount of times that you have been convicted, found guilty of them, not the amount of times you've been rounded up with a whole bunch of people as a suspect.
Why are we saying propensity to commit? Why are we not saying propensity to be convicted?
Propensity to commit could never be deduced or presumed from arrests, Your Worship. It has to come from something factual. It has to come from convictions.
You see, I'm not arguing the case for the state. I'm raising this question for my own benefit because at the end of the day, I'm the one who has to give judgment and
I
say
understand. That's correct.
there is or there is not. I don't know where the state is going to raise this point, but I'm raising it as an officer of the court. Here you are, 4 matters against you. Are we not having here the case of a propensity to commit offences? Then I'm expecting you to address me on that. Is there no propensity, or there is propensity?
There could be no propensity unless the state is bringing something to the table that shows my client had committed these offences. There can't be a presumed propensity, Your Worship. Especially not in these circumstances. There are various cases that's coming in and out of this court and the courts around us that are now, and it's been televised, that are now linked with one another. The Chatsworth case is now said to have gone to, it's adjourned to 10 June to maybe be consolidated with this one. So, or another one. So at this point in time, the state is grappling, maybe, and the one in DC-10, for which my client is on our bail as well, my learned friend had also indicated that is being adjourned to be consolidated with these other matters. So ultimately, perhaps a mistake was made affecting different arrests for various leads, making it appear as if there are 4, 5, 6 different cases, different persons for each case, where it should have been one arrest in one case. That's the only reason I can prefer to court of why my client is now sitting with 4 pending matters, because I've already been told DC-10's murder matter is going to be consolidated with this matter. Chatsworth matter is going to be consolidated with this matter. So then in that instance, it is not applicable now, but that then falls away, and it's just all one matter. So in essence, I can't say, unless my client is convicted or carries previous convictions, the presumption or the presumption of propensity cannot be said to be applicable here if there's arrests. Arrests are not going to point to guilt in this matter. They are confusing the matters as well, Your Worship. I get confused when I sit in DC-10 and my learned friend said to me, we're consolidating this one with the other matter. I'm saying, on what basis? And they won't disclose the basis either, Your Worship.
We can argue about this until cows come home.
That is correct, Your
But
Worship.
the question that comes, that boils down is it propensity to commit offences, or is it propensity to be convicted of offences?
Yeah, there's neither, Your Worship. There's no propensity to commit offences. There's nothing before court.
Is it propensity to be convicted of offences?
It's a propensity to be, in essence, my client's dad was a taxi owner, and he passed away. So I think it's a propensity to be rounded up as the usual suspect when taxi violence happens, and not all of them, and actually quite a few, do not land up at trial, Your Worship. More often than not, charges are both drawn against half, more are added. So I would rather say it's propensity to be rounded up as the usual suspects when there's violence in that area. But it's not a propensity to commit offences, Your Worship.
And I read your founding affidavit some time ago. I did not have time to revisit it again lately. Exhibit
C, Your
C.
Worship. Yes.
Am I understanding you to say that there is the state case against your client is weak?
That
He
is correct,
also
Your
going to be applying for discharge in terms of Section 174?
No, most certainly not a submission in my papers that my client will be asking for a discharge in terms of Section 174, but during trial. But my submission is it's weak, it's exceptionally weak, and there are further considerations in my founding affidavit saying that the High Court has already considered this matter. It saw the affidavit of Mr. Padbu. It saw the record. It knows about this. My client has been released on bail on 7 matters. On the founding affidavit, there's the High Court order. Attached to that is the record. The exhibits is my client's affidavit, the founding affidavit of the investigating officer. And that founding affidavit clearly says there's 7 other cases, and the High Court yet still granted my client bail on appeal.
That's not where I'm going. Where I'm going is, am I understanding you to say that there is a weak state case against your client when he is alleged to have been found in possession of a murder weapon a few months after the murder was committed?
Yes, Your Worship. It
It's a
is
weak
most
case.
certainly my submission. The submission in respect of that is, firstly, if you have a firearm that's alleged to be linked to 7 or 5 offences, say around the coast, these firearms might, or this firearm might have been in possession of another person at another time. So it's not to say that if this firearm, that's why Mr. Padbu had corrected the magistrate and said, no, it's a firearm that's connected to these offences. He didn't want to commit to say it's my client. My client was found in possession of the firearm, allegedly so. That firearm is now linked to this matter. And I've already addressed that in my affidavit, saying it's not the same firearm. The state has already said the second firearm in this matter has not been recovered. And it's heads of argument that says the one firearm is sitting with the Chatsworth matter and the other firearm my client is charged with. It is incorrect, Your Worship. So, no, I would say...
That is why I'm raising this, because you are saying your client will be discharged in terms of Section 174. Will he not be called upon to come and explain his possession of the firearm? That is, if it is proven that he was found in possession of that firearm, because that is what the state is alleging. Does 174 feature here when he is found in possession of a murder weapon and he does not have to explain his possession?
Your Worship, in essence, maybe a Section 174 discharge, that's upon that minimum evidence upon which a reasonable court could convict and put him on the back foot in case he incriminates himself. Your Worship, then if he's not granted a 174 application, then he most likely would be in a good place to close his case and then have the state...
But you say in your founding affidavit, I will ask and I will be granted 174 discharge.
I did not say that in my founding affidavit, Your Worship. I
You
think
did
it's
not?
it was another one. It was for another applicant, Your Worship.
Okay. So
I
are you
wouldn't push it that
prepared
far.
to concede that he may have to explain his possession? Because
he might-
it's not in all murder cases where a murder weapon is recovered and found.
That is correct, Your Worship.
Yes. So if you are found in possession of a murder weapon, you need to explain your possession, and the doctrine of recent possession also come into play. Is it not so?
Yes, that would be correct. But I was not the person, and my client was not the person that alleged. I think it was my learned friend, Mr. Mdlocha's affidavit that said that he will be granted a discharge. I did not allege that in my affidavit. But while the court had asked me that, I had said, I was sort of caught off guard, Your Worship. That was one of my submissions, my client's submissions. Any further questions from the court, Your
No,
Worship?
no. Anything further you wish to say?
Nothing further, thank you,
You're
Your
not an accused, you're not a witness. I'm just asking you to assist me, clarify some points.
No, thank you, Your Worship. The court had me sweating bullets. No further submissions. Thank you, Your Worship.
Thank you. Mr. Jefferson, it's 10 to 1. Will you be done in 10 minutes?
Excuse me, I may be done in 10 minutes, but Your Worship may not be done with me in 10 minutes.
Clarifying some of the things that I've seen you jotting down already, the points that came out during the submissions by Mr. Mlojwa.
Very well,
So
sir.
will this not therefore be an opportune time to adjourn for lunch break and maybe take a shorter lunch and come back earlier so that you will not be interrupted and I will not be interrupted as well?
I'm completely in Your Worship's hands, Your Worship's court.
With the permission of everyone involved, I propose that we adjourn for lunch now so that we start at 2 o'clock and continue because Mr. Jefferson is the last person on the applicant's side and then we can hear the state's case. That will also afford me the opportunity to look at the state's heads so that I can also engage them.
I do not see Paul in the court's hands. Did you see Paul in the court's hands?